So I make it 10:31. Good morning, everyone. Welcome to the very first webinar by Devereux Chambers in its Elevenses series. Now, if we have any technical issues, please bear with us on this occasion. We will try and sort it out for next time. Please use your feedback in order to let us know. The idea behind this series is to have something issued weekly, focused on providing useful content, but in an informal manner. And each week we'll have a different topic and a different series of speakers to give you a brief update on what we think is interesting out there. But of course, if you have ideas, do please use the feedback function or indeed the Q&A right at the end to provide some details for other ideas. And the aim for us on every occasion, we'll start at 10:30 or just thereafter, is to be finished by 11:15 so that it really is an Elevenses. It takes no longer than a decent cup of coffee. So in order to optimize on the use of the time, what we're going to do is to ask you to put any comments and questions you have about the subject that you're listening to in the Q&A, if time permits, and if it's something that can be dealt with very quickly, then the speaker may be able to address it towards the end of the session. Alternatively, it may be something that is capable of being addressed by email or separately after the event. And might we suggest that just for the sake of preventing feedback and for ease of use, that everyone who is attending please mutes their microphone. And as I've said, do please at the end of the session use the feedback in order to help us improve our service and our offering. And indeed, you might even want to talk about whether, if an informal chat, we ought really to be dressed formally or informally. Clearly, pajamas are out. So anyway, might I just deal very quickly with what's happening in the courts at the moment, and then I'll hand you over to the star of the day, which is Chris Stone, on his subject. So one of the many things that's been going on at the moment is the courts are trying to deal with the interruption caused by COVID, and variously, the tribunals and the courts have been issuing updates quite frenziedly in some cases initially, but things seem to have relaxed a little. At least they've reduced the frequency of issues of updates. So in relation to the FTT, as you all know, or may well know, the litigation has been stayed. All litigation at the FTT has been stayed by general order for 28 days, and all directions have also been stayed by an equivalent time. We understand that the FTT is at the moment using the time to go through the cases that are currently listed in order to in effect triage them. So the more recent, the nearest to be heard cases are being triaged first, with the idea that a questionnaire is being sent out to those people. Those hearings are obviously cancelled, but to the parties, sort of an informal questionnaire in two parts, but it's very short. Is being sent out, basically finding out whether or not the case is urgent, whether it is capable of being dealt with on paper, and whether it is something that the parties really do want to have an oral hearing. And if they do want to have an oral hearing, whether they're happy to have it by way of telephone or video. Now, some of the questions appear to be tautologous, but if one bears in mind what they're trying to do, which is to try and see what cases need to be dealt with first, and urgently, or can be dealt with on paper, then I think the answers are reasonably straightforward. It's not clear how soon the FTT is going to be able to deal with video hearings or indeed telephone hearings, but much will depend on the willingness of participants, especially at the FTT, given that it tends to be witness heavy at the FTT, to be willing to have video hearings. Clearly with multi-witness, multi-day, multi-cross-examination sorts of cases, especially if there are experts, it just may not be appropriate to have it by way of remote hearing, even by way of video. In terms of other jurisdictions outside tax, there are practitioners within chambers who've got some other experience, so if you would like some assistance on that, do please contact chambers and you'll be put in touch with someone who can help you. Coming back to tax in relation to the UT has also issued general guidance. Generally, all cases will now be held remotely, unless there's a very good reason not to, and the party objects, and remote hearings will be public hearings generally and will also be recorded. In the High Court and the Court of Appeal, there's guidance available online, and the recent experience in the Court of Appeal has been that hearings are, well, they're trying very hard in order to make sure that there is continued access to justice, to have hearings held by video conference, generally using Skype for Business, but if the parties are unable to use Skype for Business, then they are willing to countenance other forms of having remote hearings. And really the attitude was very can-do. I did the first remote hearing for the Court of Appeal very recently, and they were very willing to get involved and to make sure that test sessions were run so that all parties could participate properly. It also meant that there were certain changes to the operation. For instance, no one had to stand up when addressing the Court of Appeal. There was no standing and bowing or scraping, and certainly there was no wigs and gowns to be worn. And then one comes to the Supreme Court. The guidance is brief and to the effect that hearings will continue and they will be remote. Again, a colleague of mine, colleague in Chambers, Akash Norbert QC, recently did a hearing in the Supreme Court, and they were keen to deal with it remotely. And they, although there is generally no robing in the Supreme Court, there was also no need to stand and address the court. Finally, I think there's just that this isn't actually on the official Revenue website, but it has been brought to my attention by another colleague in Chambers, Ms. Lemos, that the Revenue have put on temporary hold all corporation tax and VAT compliance checks. This may be happening in relation to other compliance checks as well. But that's something that appears also to be happening. So that's as much as at the coalface as I need to tell you about at the moment. Do keep an eye on the relevant website, which is the HMCTS website, which gives all the guidance on COVID-19 and the way the courts are operating. And now I'm going to hand you over to Chris Stone, who is a member of Chambers and who appeared and succeeded in the case of Arron Banks. Over to him.
Thank you very much. Thank you, Bernard. And thank you all for attending. I think we're not quite in the league of Joe Wicks with people from around the world, but it's very pleasing to see the interest in this webinar, nevertheless. And as Aparna said, the hope is that a regular weekly webinar on a topic of current interest will become a fixture for you, or at least until life returns to some kind of normality. Turning to the case of Mr. Banks, Section 24 of the IHTA provides an exemption from liability to inheritance tax on transfers of value to political parties, defined for those purposes, and in the same way since 1975, as having, at the last general election preceding the transfer of value, 2 MPs elected to the House of Commons, or 1 MP and at least 150,000 votes. Mr. Banks made donations, personally and through a company controlled by him, at a time when UKIP didn't meet those conditions. He accepted, therefore, that he couldn't rely upon the exemption on its face. But it was alleged that the measure was discriminatory, contrary to Article 14 of the ECHR, taken with Article 1, Protocol 1. It was also said to interfere with his rights under Article 10 and 11, and somehow it was said that he could rely on a breach of UKIP's rights. But all of those arguments were dismissed without troubling the scorers, and I don't think we need to say anything more about them. Additionally, it was alleged that the section breached Mr. Banks's rights under EU law. Rather ambitiously, and you might say ironically, a statutory provision said to make it fiscally less attractive to donate to UKIP was alleged to undermine the functioning of the European Parliament. The Upper Tribunal found that there was no evidence of breach, and in any event, the provisions of the TEU relied upon by Mr. Banks didn't have direct effect. The focus of the argument in the hearing and the judgment was upon the Article 14 claim, and that's essentially what I'm going to speak about. And so the theme for the next 20-25 minutes is going to be the lessons learned from bringing Article 14 claims, lessons learned for those bringing Article 14 claims to challenge tax exemptions. If I can just bring up the relevant provision, of Article 14, so everybody has it in mind, the enjoyment of the rights and freedoms set forth in the Convention. So we see there that Article 14 can't be relied upon by itself, it has to be relied upon in conjunction with another substantive right protected by the Convention, shall be secured without discrimination on any ground, such as sex, race, colour, language, etc., or other status. And those two emboldened, second and third emboldened passages, discrimination on any ground and other status, what do they mean and how do you apply them, were very much an issue in this appeal. The further issues arise if there is a difference in treatment on one of the prohibited grounds. How can that difference be justified? And then there was a final issue, if there was discrimination contrary to Mr. Banks's rights under the ECHR, could the tribunal give an interpretation of the legislation that conformed with his rights? And those are the themes for the webinar that I'm going to take in that order. So firstly, on discrimination, what does it mean in this context? The FTT's approach has been quite simplistic. Essentially, Mr. Banks supported UKIP and he donated to UKIP as a manifestation of that support. He was assessed to tax, while supporters of other parties weren't. Therefore, it was said there was a difference of treatment on the grounds of political opinion. The FTT accepted there was no direct discrimination. So in effect, it assumed that there must be indirect. It didn't carry out any detailed analysis of whether there was or wasn't. But the analysis under Article 14 is not so simple. There are three types of discrimination which have been recognised by the courts in respect of Article 14. And it's very important when considering bringing an Article 14 case that you figure out which you are alleging before pursuing the case. The first is direct discrimination. There must be a difference of treatment between people because they have what would be termed under domestic legislation a protected characteristic, or for Article 14 purposes, a status. The legislation will use the protected characteristic to choose between people, or it will have a criterion that is indissociable from the particular protected characteristic. For example, if men under the legislation are treated in one way and women in another, there would be direct discrimination. If married couples are treated in one way and cohabiting couples treated in another, that would be an example of direct discrimination. Indirect discrimination, for the purposes of Article 14, encompasses two different types of treatment. The first is indirect discrimination, which would be recognised by someone familiar with domestic law under the Equality Act. And that is a measure which is facially neutral. So it doesn't use the status as the differentiating criteria, but it has a disproportionately prejudicial impact on the group sharing that status. The other type is subtly different and is not recognised as such under domestic provisions, and that's what, I'm afraid I'm going to butcher the pronunciation, is called phlemenos discrimination, deriving from a case by that name. And that is the idea of failing to treat people in different situations differently. So to give an example, if lone parents with children under the age of 2 find it much harder to work, applying to them the same benefits cap as those with older children, rather than recognising this difference by removing the cap, could amount to discrimination. For anybody interested in looking at the distinction between those forms of discrimination further, probably the clearest explanation I found in the authorities was by Sir Patrick Elias in the Court of Appeal decision in DA against the Secretary of State for Work and Pensions. It wasn't suggested in Mr. Banks's case that phlemenos discrimination had any application. So the Upper Tribunal was concerned with direct discrimination and what I'll call indirect discrimination simpliciter. The assertion that that Section 24 directly discriminated against Mr. Banks because of his political opinion was obviously wrong. The legislation does not state on its face that a particular specific party qualifies and that others don't. The simple fact that UKIP did qualify as a political party under this definition after the 2015 general election, when they had 2 MPs elected, shows that the measure can't be directly discriminatory. In respect of indirect discrimination, the Upper Tribunal found that there was simply no evidence and no finding of fact by the FTT to establish a disproportionately prejudicial impact of Section 24 on UKIP supporters. The bare fact that UKIP didn't qualify for the exemption at the time that the donations were made is not itself sufficient to amount to evidence of indirect discrimination. As I'm sure you know, indirect discrimination is often proved through statistics. So, for example, if the police impose a minimum height restriction to be a police officer, and you can show that 80% of women are smaller than that height and can't therefore qualify, but only 20% of men, it's therefore harder for women than men to qualify, and that could be grounds for a finding of indirect discrimination. It's not necessary to bring an indirect discrimination case to have such statistics. But I think one thing you learn from the Banks decision is that you must at least produce some evidence to establish what in the authorities is referred to as a prima facie case of indirect discrimination. In the alternative to his argument that there was discrimination on the grounds of his political opinion, Mr. Banks raised in the Upper Tribunal for the first time two alternative statuses, and it was said that there was discrimination on those statuses. The first was that it was said that he was a supporter of a new party, and the legislation indirectly discriminated against new parties, as against established parties, because it was said, in our first past the post system, it is harder for a new party to get an MP. And there was a finding of fact in the FTT's judgment that the legislation did make it harder for new parties to comply. But the difficulty with that as an alleged status is that it has no objective measure. What is a new party? We know that UKIP was founded early in the 1990s, which incidentally is around the same time as the Green Party, and the Green Party had an MP in 2010. We know that UKIP was older in 2017 than it was in 2015, but it didn't have an MP after the 2017 election, and it did after the 2015 election. So, as the tribunal found, there's no way of determining when a party stops being new and becomes established. So that cannot be used as a criteria if you cannot objectively measure who is one within the group and who is not within the group. The second alternative way that the case was put, was that it was said that there was discrimination because Mr. Banks was a supporter of a party without an MP. Now here we were finally getting to the real reason for the difference in treatment. Whether a party meets the criteria in Section 24 depends on its previous electoral success. In short, if you support a party that had the requisite success at the last general election, you get the exemption. If you support a party that didn't, then you don't. So it's not about which party you support per se, but whether that party was successful in the last general election that counts. The problem that the Upper Tribunal found with this alleged alternative status was that Mr. Banks was effectively defining his status by reference to the less favourable treatment that he alleged to have suffered. So he was saying, in effect, I don't get a tax exemption because I'm in the group of people who don't qualify for the tax exemption. There was an arbitrary dividing line between an eligible group of people and an ineligible group of people, and he's chosen a status which is defined solely by reference to that dividing line. So the status, and a further point, the status, i.e. supporting a party that doesn't have an MP, has no independent existence outside of the Section 24 test. Its only relevance is in determining whether or not you get the relevant tax exemption. Now, the concept of other status has been greatly relaxed in recent years in a number of Supreme Court and Strasbourg decisions, so as to be almost meaningless. A number of the Strasbourg decisions appear to proceed on the basis that there is another status without really going into a detailed analysis of whether it exists or not. Many things have been found to constitute an other status, and is certainly a much, much broader concept than the domestic concept of protected characteristic in the Equality Act. However, there is one principle that still exists since the Supreme Court's decision in Stott, and that is the need for the status to exist independent of the less favourable treatment complained of. that was found in, there was a detailed analysis in Stott of this independence existence condition. And although Lady Black, for one, doubted its utility, none of the justices in Stott said that it did not exist. And in any event, their comments on it were obiter, whereas the Supreme Court in Doherty had relied upon the lack of independence existence as the reason to find that the unalleged status wasn't an other status for these purposes. And the Upper Tribunal in this case has confirmed that the principle still exists, and so it's something that must be considered before launching into an Article 14 claim. And so on that basis, the Upper Tribunal dismissed this alternative status. So just to sum up on proving discrimination, I'd say before launching into any Article 14 complaint, analyse very carefully how the legislation works. Which group does find it harder to qualify for the tax exemption, and why? What is the mechanic by which the legislation makes it harder for them to qualify? How do you define that group? And how are you going to prove the discriminatory impact? Turning then to the issue of justification. A difference in treatment on the ground of a protected status is not necessarily discriminatory because it can be justified. And the question of justification breaks down into two sub-questions. Firstly, does the measure pursue a legitimate aim? Secondly, if it does, is the measure proportionate to that aim? Establishing the legitimate aim first off then. Of course, it will be for HMRC to establish the legitimate aim. I would say if there's a lack of clarity at an early stage, for example, in HMRC's statement of case about what the legitimate aim is, then it may be something that is in your interest to clarify at that stage, perhaps by asking for further and better particulars. It's probably easier to deal with it in advance than it is to deal with on the hoof. Sometimes the government body will lead witness evidence about the legitimate aim, especially if the case is dealing with a new measure, which is being considered recently, and where the government accepts that there is a difference of impact on different groups, and there are officials who have been involved in the drafting of the legislation or the policy, and they're able to give evidence to justify it. It was said on behalf of Mr. Banks and the FTT that in this case, HMRC couldn't establish a legitimate aim for the simple reason that it had no witness evidence. But you must remember the very different circumstances of this case, which is it was concerned with a 40-year-old measure, and there's no suggestion that the aim of the measure now is any different from what it was when it was first enacted in 1975. It's clear on its face how the measure operates, and we also had access to Hansard material of the committee debate about the introduction of the measure. The FTT found it unnecessary to refer to that material. The Upper Tribunal found it helpful and important. For your note, the House of Lords case of Wilson is authority at the highest level for the appropriateness of looking at Hansard material in order to determine the legitimate aim in the Human Rights Act context. And there are some passages from Wilson which have been extracted and quoted by the Upper Tribunal in this case. Of course, on legitimate aim, HMRC will be given a substantial degree of deference about whether a stated aim is legitimate or not. The Upper Tribunal found that the aim of the legislation was to provide tax relief on donations to political parties that are participating in parliamentary democracy by being represented in the House of Commons and not in respect of individual independent MPs. The crucial point of that and the distinction from the FTT is that the FTT found that there was an aim of channeling donations to organisations that were participating in democracy generally, whereas the Upper Tribunal accepted HMRC submissions that it was participating in parliamentary democracy by being represented in the House of Commons, which mattered. And the reason that matters so much is that when you come on to justification, a measure that looks proportionate when you know that the aim is to fund monies or channel monies towards parties participating at Westminster is very different from a measure which is purportedly looking to channel monies to political parties generally. As to the test for justification, precisely what is the correct test for justification in an Article 14 case in the tax context is not settled. And the issue is left unresolved by the Upper Tribunal in this case because it didn't need to decide it. And in any event, the issue of justification in this case is technically obiter because the Upper Tribunal found that there was no interference with his rights in the first place. However, because there was a lot of argument about the test, there is some quite considerable consideration given to it in the Upper Tribunal judgment. By way of guidance, I would say that in a straight Article 1, Protocol 1 case, so not an Article 14 case, tribunals are bound to follow the approach adopted in AXA General Insurance, which is to apply the four-stage test, which concludes by asking whether, weighing all relevant factors, the measure adopted achieves a fair or proportionate balance between the public interest pursued by the legitimate aim on one hand and the interest of the individual on the other. And the burden is very much on the state body to justify or to show that the measure achieves that fair balance. In contrast, it's been made clear recently in the Supreme Court decision of DA and others against Secretary of State for Work and Pensions, that in a case of access to state benefits, including, for example, pensions, that analysis has been replaced by a single test, and that is the impugned measure manifestly without reasonable foundation? And it is for the person challenging the measure to show that it is manifestly without reasonable foundation, and therefore a much easier test for the state to satisfy. Now, in paragraph 66 of his judgment, Lord Wilson does say that in practice, the burden of proof point should not matter because the state body will have to lead some evidence to show that the measure had some rational grounding. There are arguments about which test should apply in a tax context where you have an Article 14 claim. There are arguments for why the test should be restricted to the manifestly without reasonable foundation test should be restricted only to benefits cases in which it's been applied to date. But it can also be seen as a tool to use whenever the particular circumstances of a case make it appropriate for the court or tribunal to give the legislature a substantial degree of deference. So what you'll have to consider is, in the particular circumstances of your case, what are the factors which go to support arguments about which test should apply. In this case, there were four factors which, as I said on behalf of HMRC, showed that manifestly without reasonable foundation was the appropriate test. Firstly, tax is seen generally as an area within the legislative competence where courts are slow to intervene. And secondly, any discrimination that there was in this case was indirect, and there's authority for indirect discrimination requiring less weighty reasons. Thirdly, if there was a difference of treatment, it was on the basis of an other status, rather than one of the core statuses or core protected characteristics, which have been found to require weighty reasons, such as sex or race. And fourthly, the measure impugned in this case was in primary legislation. And again, there's authority to the effect that the courts must give particular deference in such cases. So although the Upper Tribunal didn't apply the manifestly without reasonable foundation test in this case, it did recognise the degree of deference that it should show Parliament in this case, applying those factors. And as I said before, it found that whichever test should be applied, the Section 24 conditions were justified. Turning then to conforming interpretation. The FTT had found that there was a breach of Article 14, but said that it was not competent to give a conforming interpretation under Section 3 of the Human Rights Act. It therefore dismissed Ms. Banks' appeal. The Upper Tribunal, having found there was no breach, again didn't need to determine this point, but it went on to determine it anyway in light of the submissions it had heard, and found that it would agree with the conclusion of the FTT, although its reasoning is subtly different. And there is some learning in the passages in the judgment, which are useful not only, of course, for ECHR challenges, but also EU law challenges, given that the issue of conforming interpretation arises in both contexts. I do say it's interesting to observe that for HMRC, its interests under Section 3 of the Human Rights Act and under EU law will often conflict. Under Section 3, it's generally better for HMRC to argue that it's not possible to have a conforming interpretation, because in that case, the tribunal doesn't give any other interpretation of the legislation. It simply has to apply the legislation, and an appeal against the legislation, as in this case, must fail. Whereas for EU law challenges, it will often be in HMRC's interest to have a conforming interpretation, because the alternative is that you disapply the provision, and so you disapply the tax charge entirely, or at least to the extent necessary to protect the taxpayers' EU rights. I don't need to restate the general principles about conforming interpretation. They'll be familiar to you, I'm sure, but it's very well known that the obligation under Section 3 is very broad. It goes beyond the tribunal's usual tools of interpretation. For example, there doesn't need to be ambiguity in the legislation. The tribunal can read in or take out words, and it can change the meaning of the legislation. But the power under Section 3 has its limits. The question is, at what point does interpretation trespass into the field of what Lady Justice Arden described in IDT Card Services as lawmaking? In Gaydon, Lord Nichols expressed the limit in two ways. The very well-known idea of not going against the grain of the legislation, but also later in the same paragraph 33, he said this: "Nor can Parliament have intended that Section 3 should require courts to make decisions for which they are not equipped. There may be several ways of making a provision convention compliant, and the choice may involve issues calling for legislative deliberation." So a conforming interpretation will not be possible where it involves the court or tribunal exercising choice, taking a decision in relation to third parties' rights. For that, you have the Court of Appeal in IDT Card Services. But I would say what Lord Nichols says in that passage I just quoted actually goes slightly broader than that, and is more broadly put in the EU law case by the Court of Appeal of Vodafone 2, where the court recorded that it was common ground between counsel that the exercise of the interpretive obligation cannot require the courts to make decisions for which they are not equipped, or give rise to important practical repercussions, which the court is not equipped to evaluate. In the FTT, Mr. Banks put forward a number of different ways of redrafting the legislation, all of which would, conveniently for him, have resulted in him getting the exemption. The FTT said that it was not equipped to make that choice. The Upper Tribunal rejected the appeal on this point because all of the suggested interpretations would go against the grain of the legislation and be inconsistent with its fundamental feature. So you see there the same conclusion, but via a different route, with the Upper Tribunal focusing on the grain of the legislation. The Upper Tribunal rejected the submission that the FTT decision in Panay establishes that in tax cases, a conforming interpretation does not go against the grain where a tax relief is extended or a tax charge restricted, so as long as there is still scope for some taxpayers to be outside the scope of the relief or within the charge of tax. That is what the FTT said at paragraph 99. But with respect to the FTT, in the Panay case, but with respect to the FTT, it cannot be correct when put as broadly as that. It must depend on how you are changing the scope of the legislation as to whether it is consistent with the grain of the legislation or not. To take an example in this case, it was suggested, one suggested amendment to the legislation was to change it so that it applied to European elections. That would extend the relief, and there would still be lots of people unable to qualify. But that doesn't mean that it is consistent with the grain of the legislation. As the Upper Tribunal observed, the legislation was specifically targeting donations to parties participating in parliamentary democracy at Westminster. Extending it to Europe, which has its own funding of European parliamentary parties, would be something quite different. And the Upper Tribunal found that the issue of how parties should be funded is quintessentially a matter for Parliament and not the tribunals, such that the FTT was right to say that it was simply not equipped to make the choice. Just pausing there, I've been asked by one participant, is it right that Judge Mosedale's decision in Panay is itself subject to appeal to the Upper Tribunal? I understand that that is correct. In the Upper Tribunal, there was reference to Panay, and Marika just confirmed is correct. There's reference to Panay and Gallagher, and I understand that certainly in both, permission has been sought. Whether permission has been granted in Gallagher or not, the short point is that both of them considered conforming interpretations, and in Gallagher, on this point, it was said by the FTT that because there were a number of different choices, it couldn't make that choice. It wasn't equipped to do so, but that is being, as I understand, challenged in the Upper Tribunal as well. So the difficulty for the taxpayer is that if legislation is criticised in a number of ways, you won't know before the judgment precisely which way the FTT is going to find that the legislation fell down. How was the legislation in fault? And therefore you don't know what interpretation will be required to rectify it. The result is that you put forward a number of different interpretations, and then you run the risk of being criticised by requiring the FTT to make a choice between them. There are a couple of different ways of approaching this. I think one could be to ask for a split hearing, or to be able to make submissions in writing on conforming interpretation once the liability decision has been made. Or you could make it clear to the tribunal that is not in fact being required to exercise a choice if it can be shown that there is only one relevant conforming interpretation that follows from the liability decision, whatever that is. So again, to take an example in this case, one of the other criticisms of the legislation was that it looked at the previous general election and didn't take into account that parties, such as UKIP in this case, could get an MP at a by-election. Now, if that had been accepted, then the relevant conforming interpretation would have been quite obvious and could only have been to amend the legislation to allow for by-elections to be taken into account. Extending it to Europe or some other interpretation would have been irrelevant. So the FTT isn't really being asked to make a choice. So if you can tie a specific interpretation to a specific criticism of the legislation, I think that does effectively deal with that issue. But there will still be issues in which there is a concern of the FTT as to whether it is competent to make decisions about how legislation should be reinterpreted or effectively rewritten. So again, a further criticism in this case was that there was a requirement to have an MP, and it was said that that disproportionately impacted new parties because it was harder for new parties to get an MP because of the first past the post system. They could get votes, and in this case, UKIP in 2010 had 3.1% of the national vote, but it couldn't get an MP. And so the suggestion was that the legislation could be amended and you could replace an MP threshold with a vote threshold. But the trouble for the FTT there is, how does it decide where is the line drawn? Is the line drawn at 3%? If it had been, then there were parties that did have an MP which wouldn't actually have the necessary percentage share of the vote to qualify for the exemption. So there you're obviously impacting third-party rights. So these are issues that really do fall within the consideration of Parliament, and it's not for the tribunal to step in to move what may be described as an arbitrary line from one place to another. So concluding then on what I've been saying, there is clearly scope for using Article 14 to challenge this discriminatory application of tax charges and exemptions. One advantage of doing so over a straight A1P1 case is that you only have to show that you are within the ambit of A1P1, not that A1P1 has actually been breached. And the requirement to pay tax or not getting a tax exemption will generally come within that ambit. However, this is not a straightforward area of law. As I hope I demonstrated in this brief run through in the time we've had, it requires careful analysis at the outset before you launch into such a claim to establish that you have a coherent case that does hang together and that you've properly considered how it is that the measure impacts upon a particular group, and to deal with the arguments that will be raised by HMRC as to justification. And this is all in a tax context in which many FTT judges are going to be reticent to interfere with a decision that's been made by Parliament, particularly in primary legislation. And there are numerous authorities that show that a large degree of deference should be shown to Parliament in those situations. So even if it's possible to show that there was a difference of treatment on a prohibited ground, establishing that there was breach is often not going to be easy. So just to wrap up, just within the time limit we permitted ourselves, thank you very much for attending. As I said at the outset, it's great to see that there is some enthusiasm for webinars such as this. We hope you can attend next week when Akash Norbat QC will be speaking about the implications of COVID-19 for individual residents under the SRT and corporate residents. Don't forget, you can use the Q&A or the chat functions. I know some people have been using it to say which of the list of proposed topics that we sent out in the original invitation you got you want to hear about, or please feel free to suggest topics of your own. I would want to thank the marketing team at Devereux for setting all of this up in relatively or in very quick form. Hopefully it's a format that in these strange times you find useful. Please do, if you can, take 1 or 2 minutes to fill in an electronic questionnaire which you'll receive after the webinar, because we want to make this series of webinars as relevant and useful as possible to you. So if you have any suggestions about, let's say, the content or the form or what we should be wearing, then please feel free to give us that feedback, and we'll try to take it on board. I've got a couple of minutes. If there are particular questions on this subject, then do put them on the chat. Otherwise, thank you very much for attending, and hope to see you electronically at least next week. Thank you very much.